The amount of uncertainty concerning the number of future claims is much less than the amount of uncertainty these days concerning the values of claims going forward. Yes, there's uncertainty as to the number of meso claims that will be filed going forward. Not much uncertainty as to the incidence of meso as a disease, but some uncertainty as to what percentage of meso victims will sue any particular defendant. But that level of uncertainty is relatively small compared to the uncertainty concerning what will the value be of those claims going forward. And what I'm going to start by addressing, and what this first slide touches on, is the fact that over the past 10, 15 years, there have been some very big fluctuations. Prior to 10, 15 years ago, the values of asbestos claims were relatively stable. Not stable, but much more stable than they have been in the past 10, 15 years. Then, as you all know, in the late 1990s, there was a huge upsurge in the number of non-malignant claims that were filed. And these took up a great deal of space in the tort system. They contributed significantly to the aggregate cost faced by asbestos defendants. And that spike, as everyone knows, went away relatively quickly. The second spike was, it followed the first spike, the non-malignant spike, was followed by a massive wave, as everyone knows, of most of the principal asbestos defendants. They all filed bankruptcy. And that had big consequences in the tort system. The remaining defendants were the defendants that had previously been peripheral to the asbestos litigation. The plaintiffs, of course, turned their focus to those remaining defendants. The number of meso claims brought against those once peripheral defendants, the number of claims against them skyrocketed, and the value of the claims that were brought against them went way up. And suddenly you had the GMs, Bondexes, Garlocks of the world, who in the 90s had de minimis asbestos exposure, maybe $1 million or $2 million per year in the case of GM. Suddenly they're looking at $30, $40 million a year cost of resolving their asbestos liabilities. And far and away that was meso claims. It's the spike in the number of meso claims and the much greater cost of resolving those claims. The central question facing anybody who wants to estimate or assess the aggregate exposure of today's current asbestos defendants is what's going to happen to the number and value of those meso claims going forward. We're now at a greatly elevated level. We were down here, if you chart it out, in the 90s. Now we're way up here. Is it going to stay up here? Is it going to go perhaps even higher, as Mr. Inselbuck and his colleagues might say? Or is it going to go way back down? Is it going to go possibly all the way back down to the 90s values, or partway, some portion of the way between where it is now and where it used to be? There was a very substantial judicial response to the surge in non-malignant claims. And point one is, what caused that judicial response? What caused it was widespread recognition of really severe abuses in the filing of non-malignant claims. The widespread knowledge of these abuses led to major judicial action that was so effective across the country that the plaintiffs, by and large, stopped recruiting non-malignant claimants. And if you look at the exposure facing any given asbestos defendant now, non-malignant claims are just a tiny portion of their expected cost. So that's point one. What prompted the judicial response was widespread abuse, recognition of that abuse. And point two is that the judicial response was actually very effective, and it fundamentally changed the state court asbestos litigation landscape. And one of the questions we're going to be looking at in a moment is with respect to the second spike. Are there big abuses there? Will those abuses be widely disclosed and recognized? And what will the judicial response be? Is it possible that the judicial response will be as effective or even close to as effective as the judicial response was to the non-malignant claims? As I mentioned, following the huge wave of asbestos bankruptcies that occurred in and after the year 2000, the meso claims against the remaining solvent defendants surged. both in number and value. And for a number of years, if you chart out the costs paid to resolve asbestos claims, the indemnity expenditures by the remaining solvent defendants, they're way up here. In the past few years, at least in the case of GM, and I have to confess that that's what I'm involved in now, so I'll give you a little bit more detail about GM than about other cases. For the last couple of years before GM filed for bankruptcy, the trend began to come down a bit. And the big question is, will that downward trend continue? And how far down will it continue to go? Now, why is it going down, and why might it continue to go down? The central cause, or potential cause of that, are these trusts that have come online that you've now heard a lot about. As you've heard, there's by now at least $35 to $40 billion in assets available to the trusts. By some estimates, that number will go all the way up to $60 billion. And as a result, the Bates White firm has estimated that meso claimants on average may be recovering more than $1 million in the aggregate from all the trusts. That is, each meso claimant in the aggregate may be recovering more than $1 million on average from the trusts. That's before you even count any of the recoveries that they're obtaining in the state court system. So the question is, how will the state court system and the exposure of the defendants evolve in response to that fact? And will that fact, that enormous source of dollars, cause the strength of the claims against the solvent defendants, and as a result, the value of the cost of resolving those claims to go down? The battle over that is being fought out in two different battlegrounds, principally the state courts, secondarily the bankruptcy courts. And the state court battleground, I won't repeat what you heard from the prior panel as to the fights that are being fought. I'd just make one or two comments concerning what's the impact of that on aggregate values. First point is, as you heard, the rules in the state courts are evolving in a number of ways. The rules concerning discoverability, admissibility of the claim forms themselves, the trust payments, those are evolving. CMOs are being adopted, some quite radical, like the new West Virginia CMO, and legislatures are enacting statutes such that the traditional joint and several liability is continuing to erode and may continue to erode even further year by year as we go forward. But even if that evolution were to stop tomorrow, and even if there were to be no further changes in the rules that apply in the state court system, one might still expect that the cost of resolving claims, the cost faced by the remaining solvent defendants, may continue to go down quite a bit. Because over the past few years, as these new trusts have come online, and it really only has been the past 2 or 3 years that the major dollars have become available, the defendants have begun to use that. And Mr. Inselbuck said that, they've always litigated the empty chair, they can continue to litigate the empty chair. Well, there's a big difference in how effectively you can litigate the empty chair. Compare on the one hand, 2002, 2003, 2004, when all the principal defendants were in bankruptcy, they weren't paying a penny. To point to the empty chair is not terribly helpful, even if the state court lets you do it, which they might not. Even if they let you do it, it's not very helpful because that empty chair is not paying anything. Now, those empty chairs are paying a huge amount. And so that in itself may have a very big effect on driving down values. Plus, to the extent discovery is permitted of these various trust claims that are being filed, it may turn out that the exposure allegations made there, a plaintiff saying, I was exposed to Armstrong's product, I was exposed to OC's product, that'll be very useful to a GM or another peripheral defendant in saying, look, the person's asbestos was caused by that product. It's much harder to show that it was caused by my product. Imagine now that the rules do continue to evolve, and perhaps even evolve quite aggressively towards a West Virginia kind of scenario. That could have even more dramatic effects in reducing the aggregate liability. As you know, The number of bankruptcies, the amount of dollars involved today is a tiny fraction of what it was 5 years ago, asbestos-related bankruptcies. Nevertheless, if you're evaluating the asbestos liabilities of a company in bankruptcy, you should be aware, or if you're involved in one of these bankruptcies, you should be aware that there's a big battleground that's just beginning to be fought in GM, in Bondex, in Garlock, over the ability to discover the trust claims and the trust payments, and the impact that that should have on the estimation. In GM, we recently got a ruling permitting us to take discovery from the trusts, and we're expecting that Judge Gerber may well give a great deal of weight to that in his estimation decision. So that's something, that's one of the big uncertainties, that's one of the big question marks in evolving areas that people should focus on if they're trying to determine the aggregate exposure of any given